What I'm going to do is I'm going to go with the flow. In other words, I can lecture or share for the whole hour or get you guys involved. I'm hoping to get you guys more involved because I provided you guys some summaries, really brief summaries of the case law in Edmonton. As everyone was saying, in 2004 I got my first buyout, and I didn't know anything about animal protection or all animal cruelty. And one of the first things that I found out in 2004 was it was with an Edmonton Humane Society officer. And she basically said, like, well, when are you going to dump this file? That's what she said. Because I guess apparently what has happened is because of lack of knowledge about the law, case law, as well as how to prosecute, it was really difficult for the Crown Prosecutor's Office to prosecute these matters. We didn't have a designated person. The law, which means the provincial statutes, which I guess you guys all know is the Animal Protection Act, and the Criminal Code, which has several sections, and there are 445 and 446, and they deal with basically animal cruelty, everything from killing animals, to poisoning animals, to hurting animals in moving vehicles, as well as causing unnecessary pain and suffering. We had probably only 1 or 2 files here in Edmonton per year, and apparently Calgary was pretty well consistent with that. In 2014 now, or 2013 I guess, because we completed 2013, we're looking at 30 to 40 files now, and a lot more criminal charges, not just simply under the Animal Protection Act. So the other thing that might be interesting for you guys to know is there are 3 major agencies that deal with animal protection here in Edmonton. So even if you guys, and I know I've got to be fair, some of you guys may not be law students, but wherever you're coming from, whatever city you're living in, generally there's going to be a policing agency, a humane society or SPCA agency, as well as the city, which is like a bylaw officer. So here in Edmonton, it's the Edmonton Police Service. We also have the animal bylaw officers, which are from the city of Edmonton. And then third agency, of course, is the Edmonton Humane Society Animal Protection Officers. I'll be honest with you, when I'm looking at this, as I sort of created this portfolio in our office for Edmonton, I do have some concerns, and maybe you guys at the end might have some ideas. Calling them the Edmonton Humane Society Animal Protection Officers, and they're paid by the Edmonton Humane Society, may create a bit of a conflict of interest. You can see what I'm saying here, because they're supposed to be actually outside. They aren't. They really are simply like a sheriff or a level 3, if you want to call it level of sheriffing or law protection officers. They're not police officers. But the name I can see being a potential conflict. I see some people nodding. You can sort of see where I'm going with that, because they actually are paid while they're separate from the Humane Society. They're actually paid by the Edmonton Humane Society. So it almost sounds like a bit of a conflict, especially what if, like in Toronto, the Humane Society or the equivalent has a problem when you have to charge yourself, right? So one of the things that when I came in and we started this actual animal protection portfolio in 2010 was that we taught them that, one, even though the Humane Society needs to make money, and I guess those of you, because there are some people who love animals and are involved with rescue groups or the SPCA or SPCA equivalent, you may want to obviously use those pictures of these horrible abuse or saving the poor animal, that was abused or blind or whatever. And I'm not belittling that. I'm trying to say that literally, as part of the business, you may want to use that. Well, my position has been, and again, I'm welcome to hearing from you guys, was that to be fair to the accused, which is part of the way we talk about prosecuting animal cruelty, we need to be fair to the accused and make sure we're not being blinded, shall we say. So I said, you basically can't use those videos and the investigation. That has to be separate. So all the materials, like pictures, the videos, when they go to those hoarding houses you've heard of, that cannot be utilized by the Humane Society. It's part of the investigation. It has to be kept separate, and the Crown has an obligation to do that for disclosure of fairness to the accused. So that's one of the basic things that I looked at. So, and the second thing here is that the Humane Society officers, who are animal protection officers, they need to keep confidential their information separate from the Humane Society. Like, in other words, there's an executive director and such for the Humane Society. They can't just share the files. It has to stay within their animal protection officers. The thing that may interest you, because I'll be point blank, most of the criminal charges and the animal protection charges under the provincial legislation are started by the Edmonton Humane Society Animal Protection Officers. And the reason why is, one, people call them, or the bylaw officers or Edmonton Police Service will call them because they are still the experts. So while they cannot, this is important to note, the animal protection officers, Edmonton Humane Society officers, cannot lay criminal charges. They can only lay those under provincial legislation. They will often, at least we've got a working relationship with EPS, with the Edmonton Police Service. So Edmonton Police Service can actually lay the criminal charges, but the Humane Society officers can't. At the same time, you can probably imagine who has the expertise. Because remember the comment I said earlier on about how, is the Crown going to drop this charge, right? Well, likewise, expertise is with the Humane Society officers. You might be surprised, though, here in Edmonton, like in Calgary, we've got a couple more in Calgary, we only have 2.5, 3 officers from the Edmonton Humane Society, animal protection officers. And because they actually help us a lot with the criminal charges with the police service, you can tell that's going to be a huge resource problem that we're facing in actually prosecuting animal cruelty charges. In particular, and we can get this later on, the issue of prohibitions. Often a prohibition will have at least when we set up it here in Edmonton, and again, this tells you how new it is. So you get a conviction under the Criminal Code or under the Animal Protection Act, and you want a prohibition, right? Because you think the person or people should not have these animals because they can't care for them or they're endangering the lives of these animals. So the next issue then comes, well, what is this prohibition? So believe it or not, where most of you guys will know about driving prohibitions under the Criminal Code or under the Traffic Safety Act, you've heard of those, or probation orders, or weapon prohibitions, DNA samples. I guess I'm not thinking civilly about some of the cases may have civilly, but criminally, those kind of things, you're familiar with those orders are in there. Or I guess if you do restraining orders or peace bonds, some of them are common law, for trying to give a different legal to other things here. They're actually forms, as we all know, as provided by the Criminal Code or statutes, as well as your courts. In other words, just court procedures, they will have them at the courthouse. The Queen's Bench, Provincial Courthouse, Court of Appeal will have those forms. Have you ever tried to look at a 447.1 pet prohibition or under the Section 13 under the Animal Protection Act? There is nothing actually directly worded in there or with the courts. So we've actually tried to set up something, whether it's legally binding or not, it's still going to be questionable because it's so near. So what I also do, besides giving, or at least in Edmonton, documents that I provided for the courthouses, I also, and again, willing to hear your brilliance again, looked at basically getting them on the record, so the accused on the record. I'm dealing with criminal matters, obviously, so accused on the record, I get them to admit that they heard this comments, that they're agreeing to the animal prohibition, that they understand what happens, that if I need to deal with them on a breach, I can then order the transcript to be sure. Although we have done a written one now too where they sign it, I just, until someone challenges it, I'm not sure what's going to happen. So I've also done it on the record, right? So it's very clear. And that's just, so that we have protect that. There's still issues though because the animal protection officers, there's only 3 of them. So how do we get them to find the time and resources to go out and check whether these people are actually, for example, we get them to register their address once they're released from custody if they went to jail. Those type of things are really hard. Or some of them, and you know that because it's a balancing act of sentencing, whether it be the provincial legislation or criminal code. Some of the courts will allow the accused to have one animal for compassionate reasons. They're living with their families, so they've got kids, right? It's going to make the kids suffer. So say that they can have 1 or 2, one dog until its death, but must register with the Animal Protection Office with their telephone number, name each year, and advise that they move within 15 days, and allow the animal protection officers at random or upon reasonable suspicion to enter in the residence. So that's something that I created, we're trying to keep in there, but it's really hard when you only have 2 or 3 officers who are behind schedule, who have 6 months on the limitations on the Animal Protection Act legislation to lay charges. It's really hard for them to go and follow up. So, unfortunately, the truth of the matter is, the defense counsel will know this too, obviously, is that it only happens when a neighbor or someone has a real concern, and then we'll get a phone call, then we can look that up. But those are some of the challenges that we're looking at when we're talking about the direction of where animal cruelty prevention or animal cruelty law is going. I think we want to take a look here in the brief time that we have. I should probably over my phone, but behind time here is probably looking at the major legislation. So, as I said, there's the Animal Protection Act, and that's our provincial legislation here. And so I've got these T-shirts here. So maybe I'll ask a question here. What is the major difference? You guys, most of you are in law school, so I see them. So between an animal protection charge that you need to prove versus a criminal charge, drug charge, versus animal cruelty. So what would be the major difference? Does anyone know?
The burden of proof beyond a reasonable doubt versus balance of probabilities.
Right, and strict liabilities actually. And I think, yeah, it's strict liabilities. So I've got a shirt that you'd like to come up or pass. So I believe, if I'm not keeping you guys interested or educating you guys, at least hopefully I did something nice for you guys here. So it's a little fun. Right. I designed this actually. It's not very exciting, but I worked with Corporate Challenge for Alberta Justice, or Alberta Justice Solicitor General. So I designed these shirts, and these are our dry fit shirts from last year. Our new ones are not ready yet, so I just thought I'd bring some as well because anything can do with the free t-shirt. But what's important is this is a dry fit, not just a t-shirt. When I went to law school, I don't know about you guys, but I have more t-shirts than I think Susan Lucci has any losses. Like it's just like you get one for every law firm, you know what I'm saying here, and for playing volleyball and soccer and all sorts of sports. So anyways, I want to keep it kind of interesting. I may need actually one of you guys who's in and does more civil work. I was walking from the parking lot to here, and you guys have a lot of ice, and I probably did my first triple SALDF today, and it's a spin, so I don't know. It's a little bit dangerous out there, so I might need you guys to do some civil law. But I thought what we could do anyways, seriously, is looking at briefly the major sort of law that we're dealing with. There's a lot, but I'm going to try to focus on just a couple of things here. So we have the Animal Protection Act, which is our provincial legislation, and I'm sorry, I didn't get your name.
My name is Sai.
Sai. So as she was saying, it's basically, when she said balance problem, it's actually strict liability, but I think we understand it's not the same test. So in other words, did the person actually have diligence? Is there a reason why, were they forced to do it? So if they allowed an animal to live in, the common charges of distress, in need of medical attention, and need of food and water or proper living conditions. Those are the major charges. And you look at section 12 and 13, those are the two major sections that you'll be looking at under the Animal Protection Act. I'm just going to give you guys an overview, guys, here, because I know time is limited and you guys are far more brilliant than me. In there, the thing is that you will find that, of course, the Crown is going to have to prove such things as the animal needs in medical care or attention, or in the case of distress, that the animal is in distress. Same thing with inadequate or improper ventilation or space or living conditions. We're generally going to need probably an expert. Or there's, of course, courts can't take judicial notice, and the police officer, the Humane Society officer, or the next door neighbor who saw it, makes the complaint, may be able to testify, maybe clear enough. It's sometimes hard to say, so you're probably safer having an expert. So often we get the videos, we take the oral evidence, the pictures, take that to the vet, and they can usually help us. If we really want to prove a case and it's kind of iffy, we may have to call an animal behavioralist. An animal behavioralist, I don't think it's more like the psychology and other reactions of the animals too. So it was very helpful in a case that actually was a criminal case, and because it is academic, I'll say it, even though I'll try to sort of sanitize it a bit. It was a charge of bestiality, and the animal was a guard dog and somehow ended up in the front seat of the guard seat with the guard security officer. So it's not a police officer, it's like one of those, going to be diplomatic here or politically proper here, but one of those agencies that deals with security late at night, you know what I'm saying here, and they have an official looking car and outfit. So anyways, the dog ended up the German Shepherd ended up in the front of the seat, and the police officer was so grossed up by what happened, he really couldn't testify because he didn't really look. Remember, bestiality is basically having sex with an animal. So he really couldn't fully describe what had happened, which was a little bit odd, but anyways. And so we managed to get an animal behavioralist to help us get a conviction, to explain the reactions of the animal, proving that it was being penetrated and such. So sometimes that can happen, right? You know, that you use the animal behavioralist in that way too. And I remember that case specifically not because it was kind of grotesque, obviously, it was also because we were doing the preliminary inquiry and the defense counsel didn't know what it was about. He was just watching, came in at the wrong time, I think. And then he whispers to me during the cross-examination, like, I don't understand what's going on here. And I explained it was an animal. And he was then kind of got sick and ran out of the courtroom. But, you know, on all seriousness here, I think the idea when we talk about in that bestiality case here, it's about respect, guys. They often say, and defense counsel often use it about, you know, respecting accused in who are being arrested or charged and or convicted, which is true. We need to show respect. Animals are not people. We've accepted that. The Canadian law is clear that they are not people. We have distinguished that. In fact, as many of you know, in the McManus case, where there was a police dog involved, that is not considered a partner here in Canada. I think there was cases in Calgary where they gave them badge numbers, but again, they're more symbolic. In Canada, they are not considered equivalent to a partner or a person. So we know that, and we also know that just generally in law. Nevertheless, and as we talk about case law here, we're saying that that we need to treat animals significantly because they are living creatures, and they often, as you know, we judge society by how we treat our weakness. And you'll see that here in Edmonton, at least, the courts are starting to see that. They actually mirror. And we may not dive into the case law because you know how good times we go, but the cases that I have, you will find that are on your summary there. Most of them will have the judges saying that, right? They recognize the vulnerability, really, that people, you guys, the justice stakeholders, your neighbors, people on the street, you guys are the voice for the voiceless. That's the only way we can get the convictions, because it's very hard, obviously, because an animal, as far as I know, we don't have a Dr. Doolittle who actually can talk to the animals and get evidence out. But you see that, you know, Parliament definitely is taking it very seriously, and you see it through the Animal Protection Act. So the Animal Protection Act, believe it or not, strict liability. The maximum fine, as you guys know, is $20,000. However, some people are trying to argue under the Provincial Offence Procedures Act, POPA, that you can ask for a jail sentence. I don't think that's, I'm not taking that approach yet unless someone above me or one of you guys can convince me differently. The reason why is I think it's legislated right in there in the code, and there's been since 2008 a huge focus on the criminal code. So I'm thinking that's Parliament's intention is if you want to, you could charge under the criminal code. And I want to bring you guys to the criminal code, sections 445 to 446 in particular. That's where you'll find most of the animal protection or animal cruelty charges. But you basically have, and there's too many to go through, but the two main ones are 445.1 in brackets for subsection 1. And that's a person who willfully causes or being the owner willfully permits to cause unnecessary pain, suffering, or injury to an animal or bird. That is in contrast to 445.1, where everyone who commits a willfully or without lawful excuse kills, maims, wounds, poisons, or injures dogs, birds, or animals that are not cattle and are kept for lawful purpose. There's too many sections to go through, but those are the two major, I'd suggest the two major ones that usually apply. So we already put up the provincial legislation, which has those 4 kind of sections. And I would say you could always go with the general one that's causing distress. Usually will cover not beating them, poor ventilation, and things like that. Now these 2 charges here are interesting because often when you think of killing an animal, you're thinking like, if it's going to a person, you're thinking some form of homicide or murder, right? So you're not going to be thinking unnecessary pain and suffering. But what about the scenario here that we have an animal that is killed, shot, stabbed, or whatever, and it's seen by the neighbor or someone on the street, which is not uncommon here. The animal doesn't have a collar, doesn't have a tattoo, doesn't have a chip. So that's the kid, you know, it says, you know, the animal's definitely killed, stabbed to death, we'll say, by someone. In the alternative, we have causing unnecessary pain and suffering. That one says nothing, the section says nothing about killing. So does anyone see what the problem is going to be, or could be? I'm not even clear. So like, what I'm saying, and because we don't have a lot of time here, is like, the problem would be is that how do we show that the animal that was killed was kept for a lawful purpose? Now, some judges, I think, might just yell at me and say, Mr. Lynn, are you for real? The dog's in the neighborhood. It's a healthy-looking dog. So what, it doesn't have a collar, leash, tattoo, or chip, right? And I would suggest to you that maybe the Crown might prove it by using the evidence of the other people in the neighborhood. Not to say they didn't actually know the dog, but they could say that it was healthy looking, that you saw it, the nails were clipped or something like that, all which would suggest it was a domesticated dog, right, or kept for a lawful purpose. I'm able to get an expert. If the animal is spayed or neutered, I'm going to say to you that's also probably evidence the animal was kept for a lawful purpose. But you just don't know. And a lot of you guys here are probably not interested in law, but you probably like animals. I know that we have obviously mandates and people here, but a lot of people, will just be honest, it really pulls upon the heartstrings. They're going to be pretty outraged, the public, if I didn't get a conviction or because I didn't think about that. I'm not going to lie to you, that was some situations we're looking at, because in the past, there's not many cases. No one really in our office has looked at that. So we have to be very careful when we lay charges. In fact, right now we have, and I can't go into too much details, but you guys all know there was the cat case with 2 young adults and a youth, and they basically, the allegations are, you've heard on the media, that they've taken this cat and allegedly killed it. Well, the question is, and that one there, it was stolen, a stolen cat, so you can use your conclusions how the Crown might be able to prove that it was a domesticated, kept for a lawful purpose. But isn't it both actually killing the animal kept for a lawful purpose and causing unnecessary pain and suffering? Can you see how they're both the same? And in case you guys are wondering, was it pineapple, which means that you can only go in one, not both. The case of R versus Monroe. Now give them to Aaron because I don't actually have the cites here with me. I have the cases here, but I don't want to look at them. That one actually says it's not pineapple. So they're different because there's different mens rea, there's different actions, there's different, one definitely has some kill, wound, or injury. The other one would be just unnecessary pain and suffering. When I say jest, I didn't mean jest, but I think that the section under unnecessary pain and suffering is an interesting one to look at, and it will be expanded. So this is where, I encourage you guys to come and say something here. Should the Crown, obviously I think we would agree that it's worse to have a criminal record in respect to restrictions on your life to liberty, things like that, the constitutional right to your freedoms, right? It is worse to have a criminal charge than the Animal Protection Act. Do we agree on that? Or would anyone disagree? Okay. And also because one would say that usually a fine, because remember I told you right now it's a maximum fine of $20,000 versus jail, maximum 5 years for the criminal code, would suggest that it's more restrictive. At least most people consider jail more restrictive. But the word distress, which is the common one usually used or often we have to prove for the Animal Protection Act, usually suggests, at least the way I understand it, an animal that is actually going to hurt or pain or suffering for a while. It's not just a momentary thing. And all of you guys had to take criminal law, which by the way was my worst, by far worst class ever in law school, which is probably why I'm now practicing as a prosecutor. Would probably agree that if I had intent and I swung at you guys, even though I didn't touch, that is actually an assault or could be an assault, correct? So you don't actually have contact, right? Well, I'm not trying to equivalent, as I said before, because the way the law is right now here in Canada, that an animal is treated quite the same here too, but what about, and these are the common things that happen often, where there's a domestic dispute, whether it be a criminal charge or not. Quite often we can't because the spouse is recanting or won't give a statement. But they'll say something, or they're mad, or they're drunk, or they had a bad day. These are all common things here. So you kick the animal. You throw it against the wall. These are very common things. Or you're walking a dog and you pull a leash really hard and yank it really hard. These are all cases that I've had too, but they're just very common things that happen. Should we just not charge them with anything? It's going to be hard to show guys, I think, the way we use the word distress under the Animal Protection Act, or using those other sections. Is it space and ventilation or anything like that? No. Is it need of medical care? No. Because remember I said there's no injuries, there's yelping. But a lot of you did, so I guess the animal lovers are going to be outraged. But, and I'm not simply looking for more work, Okay, we're gonna get very clear, right? So it brings really a conundrum. So what do? Do we just not do anything? So what we have done is we have charged them unnecessary pain and suffering. Let me ask you. I'm having a bad day or fighting with my wife. Is it right for me to kick my dog, even though there's no injuries? Was it necessary to kick the dog? Well, maybe if on the road I see this truck coming and the dog's there and I'm running, which probably wouldn't be that great, but anyways, and I kick the dog, I mean, that's kind of, out of the way, trying to protect it, right? But really, why would I need to kick the dog or throw it against the wall or yank the leash that hard? I'm not saying as a Crown, we don't want to just be frivolous here too. So, someone lost it because the dog was about to, looked like it was about to bite a kid and quickly yanked it, maybe too hard, but I don't know, that might not be appropriate if used in the public interest. But, what about someone who's, drunk? Okay, I know this would never happen to any of us, but, they're drunk outside the bar and they kick an animal, there's no injuries. Was it necessary? I think we can show probably it wasn't necessary, right? And, that it was deliberate or that they had mens rea, they had the mental culpability to do it. The next issue, did it cause unnecessary pain or suffering? Pain or suffering. And I can get an expert who will say, like if one of you punched me, hopefully not too hard, ouch, and there was momentary pain or suffering. And some people say, well, defense counsel doing their job, of course, which is, look at the best interest of the accused, saying, oh, it's so de minimis now. But really, if we thought it was a person, that would be charged with assault. And again, I know I have to be respectful and say it's not a person, but that, as we know, is kind of behavior that often, violence towards animals, often associated, everyone knows, with violence on people. And there's a huge correlation with child abuse and domestic violence with animal abuse, whether it be provincial or criminal code. So that's kind of one of the new areas. And again, I'm sure you guys all know the law, but I'm just saying this is one of the new areas we're trying to do. And we have gotten convictions on that. What is interesting is this. So you've got all those cases that you guys have there, and the last one, which you guys probably know the most about, is about Manage, which is the police dog Qantas, which is not on there, we got 18 months incarceration. Every single charge that we have had since 2010, where we've got a conviction, so that would be in August 2010, has always led to jail. So not a conditional sentence order, but has led to jail here in Edmonton. I'm going to say this very clearly, in Edmonton. So the animals, the cases that we have there, for example, Cardinal, which is where they picked up the animals and carried back through against the wall, no injuries. And Dudar, which is the case where guy was walking the dog and pulled the leash too hard, but there were no injuries, but it was yelping. They got 15 days jail and 90 days jail, respectively, with no injuries. Maybe they had a bit of criminal record, but not related. In Cardinal, the case, they also had the Gladue factors, and there was considered the inherent background of the accused as well, and he still got 15 days in jail. Actual jail time. So we basically, when defense counsel goes into and say, oh, can you take a fine for a criminal charge? I'm going like, well, how can I rationalize that? I will admit to you guys that you guys know the law here, of course, is that criminal law, in respect to the cases that we've had are all been provincial court decisions for the most part. Although I believe one of them, here we have Charles Bull, that case there was Queen's Bench. They're all provincial court decisions here in Edmonton, so they're not binding. They're just persuasive. But nevertheless here, I think, speaking to Aaron, there's just not much on law here. You guys go look through Westlaw and Carslaw and Quick Law and everything, and you guys are far more brilliant than me, I know that. You will not find very much out there, and they're certainly not in Edmonton or Alberta. There are certainly other cases out there, and you'll find the cases are, when you think there's, substantive sentences, like in the getting in the higher penitentiary time or provincial time, you won't find a lot of cases at all. I think this gets on the end. Most of them you have to do is you have to Google, unfortunately, and look at news clippings, because they're not reported or recorded right. It's the ones that are the sentences are often, when I got excited, I heard one sentence for 14 months jail, but with it was a break and enter, so it was a global sentence, right? The sentences that we have here and I gave you are strictly on the animal charge. So even though the Manage, which is the police dog case, there was a flight for police, there was drunk driving, there was stolen license plates and such, the actual 18 months in jail was only for killing the dog Quanto, right? So we're trying to look at that, and we're starting to look for deterrence factors here, is that in order to get deterrence factors and look at them, we need to look at the case law. And I'll be honest with you, we don't much have a chance if we look upon case law other than in Edmonton right now. So, for example, in Calgary, in November of 2012, sentencing, they had a case where an accused got drunk outside of a bar, was coming outside a bar about 2 in the morning. He was urinating in the alleyway. A small dog, I think it was a Chihuahua or whatever, came, kind of yipping near him, and while he was urinating, and he booted the dog. What type of sentence do you think he got? Does anyone want to guess? So that'd be Calgary. So here we're getting, 15 days for throwing a dog against the wall, 18 months jail for killing a police dog. Some of the other cases you saw, 14 months for not feeding or watering an animal and beating it so that it couldn't walk. 16 months for the gentleman who slit the throat of the dog and sent the pictures to a girl. So what do you think they got in Calgary? I'm not trying to make embarrassing.
A month.
Sorry?
A month.
Jail. Any other guesses?
Nothing.
A conditional discharge. So I know that and you guys are all going to say, well, you got to look at each case specifically, and things like that, especially when there's no case law really out there. But really, the huge diversity we do here, because on Quanto, about managed the police dog case here, when we considered the setting that was a joint submission, it was considered that yes, it's a police dog, so in a way that's worse. Now I'm going to contradict myself, but it's also a police dog, so arguably some people are going to say it's part of its job. Right, and again, I'm not trying to diminish. I'm just saying, but I've got to be balanced here. The Crown Prosecutor role is not just to get a conviction right; it's got to balance everything out there. So you have that situation here where, yes, it's like the partner, and probably it would have been the partner, Constable Matt Williamson, would have been stabbed instead of the Quanto. At the same time here, there's an argument that's part of his job, and it's almost like a weapon or a shield or such. And again, I'm not taking judgment here whether it seemed derogatory or not, but that's kind of what you're looking at. But here we have an innocent dog just walking by someone who's obviously drunk. And we're not stupid. Gee, we've all been to clubs. I'd be careful what I'm saying here. I'm sorry. Most people, I would suggest, from what I understand in my brief experience through university, have attended bars and knows what happens around closing time at 2:30 in the morning, right? And people, for some reason, alcohol is something on the system that people have to use the washrooms or the streets, right? We kind of know what happened here. I think deep down in your hearts, you guys don't know what happened here, but he kicked a dog. No reason at all. That was also unnecessary pain and suffering, obviously, too, as well. But he was charged with killing and got a conditional discharge. So that's the problem here. I have to be honest to the judges, and I have to let them know there are different cases out there. But I think you can tell we have enough cases now here in Edmonton that, we should be looking here specifically what is going on in Edmonton. I think if you guys are all interested in case law, and I will provide the cites, I mentioned the Monroe case, but the other ones are Rogers and Connors, and I will provide them at some point to Aaron just in case. I'm not sure, this may be interesting, but I don't know in case you're into those 3 cases. I'll read one of them, but they basically have been focusing on in 2008 when the legislation changed in the criminal code. It was about taking animal abuse more seriously. So it means not just simply raising the sentences up to a maximum of 5 years, but really doing something about it. I'm going to say something here and be qualified here because the Crown always has to be careful what we're saying because we represent the people. Quanto's law, I think many of you guys have heard about that. So this is in reference to the police dog that was killed. Many people feel that we need specific legislation in the criminal code that deals with a police service dog, or a dog in that type of position protecting the public to get proper sentences and to properly prosecute them. So that section, or a new section, is being introduced by Parliament. So I spent about 5 hours last week, or 2 weeks ago actually, with the various legislators working on that. But my position would be this: I owe it to you guys as members of the public, not only mention as justice stakeholders and colleagues, to look at what we have, because even what we have right now in the Criminal Code and the Animal Protection Act, we have everything still that we can use. So if we can't get the killing charge in terms of killing because it says for a lawful purpose, we can go with unnecessary pain and suffering. And I don't think, at least what I can see, the sentence would change a lot. I think most of us would agree that I don't need both charges, killing an animal and necessary pain and suffering. It's still going to be the same sentence here. But we do have things in there because the sentencing provisions, which are in 718 of the code, will tell you about what to look at aggravating and mitigating circumstances. So we might want to do, this way to get you guys kind of involved here is like, do any of the cases in particular interest you that are in the summary? Does anyone have one case that really interests them? Don't be shy, just so we yell one out too. Or even the managed case, which is the police service dog case. Actually, let's deal with it because of limited time. Do you mind if I suggest the Chaye matter? I'm going to just assist you with the Chaye matter. I'll tell you why. Chaye is interesting too because there's interesting facts, but when you guys talk about aggravating and mitigating circumstances, Chaye is Brandon Chaye matter. He's 18 years old. I'm not a sociologist or statistician, but I noticed that a lot of my serious charges involve males between the ages of 18 and 20. A lot of those files are finding serious for whatever reason. I'm not saying anything, just for some reason they're 18 to 20. Even the charges that we have outstanding right now, Conrad, where they stole a dog and killed the animal with a stone, that's going to be sentenced soon. All these ones involve usually 18 to 20-year-olds. Brandon Chaye, I think, was 18 years old at the time. As many of you guys know, he for some reason was high on drugs and alcohol. He flipped out, if I can use that term. Took a knife, slit the throat of his family pet, and then slit the stomach open and pulled out its entrails and such. He then took pictures of it and sent it to a girl he was trying to impress and force her to date him. I could make some comments, but I won't. And then he did some other stuff too, like he destroyed the house and then he broke into some other houses. And I couldn't prove it beyond a reasonable doubt, although you might actually say that there was enough evidence. He wasn't bleeding himself, and the entrails were taken, but he left these blood smears at various houses that he'd broken into, and cars with cryptic, swear words and messages on them. And so my theory was that he probably took some of the innards of the animal and continued on his way before he was caught by police on the White Mud Highway or the Yellowhead or something like that, the highway there. Anyways, on that one there, it tells you, this will also sum up like the tie between mental health issues, violence, around animals, to violence of people, and also looks at mitigating and aggravating factors. So this is like one case that can kill a lot of things, birds with one stone, so to speak. In this particular case, there was a pre-sentence report done. And a lot of you guys know in criminal cases to look at where the person's coming from, the accused, his background or her background, and things that might affect their treatment, i.e. probation orders, like how to help them, or whether they're likely to reoffend. We'll do a pre-sentence report and forensic assessment. I have the report here with me, but we won't have time to go into that. I'll give you some of the highlights, if you can call it that. Mr. Chaye had some family problems. Mr. Chaye, had lost his father, who wasn't in his life. Mr. Chaye had some alcohol substance abuse for the last couple of years in high school. Mr. Chaye was feeling a bit of a loner. Mr. Chaye had fantasies of raping women when he saw them. When he saw one of the buses, he wanted to anally penetrate them. He had gone to campgrounds and sprinkled gasoline around tents while people were sleeping. He didn't actually light it, thankfully. While he was younger, he would shoot small animals and then eviscerate them or take them apart. And the basic report said that he looked like he had some pathological tendencies and would, be a concern with respect to sexual relationships as well as with children. In other words, pathologically speaking here's a person here who is not a dangerous offender. It's the first actual criminal charge on his record, but right away it's warnings. Like actually, obviously contact our high-risk offenders, even though it's a first offense, because the report was so scary. In a nutshell, there's obviously some mental health issues, you could tell. So that's going to be more something on the sentencing, on the, I don't know if you call it mitigating side. His youthfulness, the fact he has no criminal record, those are mitigating circumstances. On the aggravating factor here, we have a horrible, brutal crime that was done, it's the family pet, so there's a bit of a trust issue too. And I use that too, and I don't mean to belittle it, but it's like leaving a lamb to slaughter. Remember, that dog might have fled if he knew it was someone he didn't know, right? But if he was I guess maybe I can make it clear. It's a family pet. I think you guys understood that. It was a family pet. So that animal's not going to know any better, right? And so he's just going to stay there, not going to know that he should be fleeing. Slits the throat, and it is aggravating that he also sent the pictures and trying to use his power, right? He's trying to get this woman, to date him, or force her to date, right? Sort of hinting that this could happen to her. It was a little awkward because actually it looked like he was trying to impress her actually by killing the dog, but that goes to the mental health issues too as well, right? But those were obviously aggravating factors. That it was a position of trust essentially, the way that it was done, the brutality, the nature of that. And those are the things that the courts need to look at. In that case this may be the first case that we may actually get a decision on. The courts gave 16 months jail time consecutive. So that means strictly on killing the dog with a knife. There were other charges like break and enter and mischief over $5,000 for destroying the family house, and he got another 10 months. This case is being appealed, so it actually may give us our first chance to have, at least here in Alberta, a really good case to utilize, depending on what the courts say, of course. It's up to the Court of Appeal, as this was another one indictment.
Can I ask a question? Is the court going to argue, is the other side arguing that the breach of trust, you can't argue breach of trust when you're prosecuting under mischief?
We did charge under mischief.
And I understand, but you're charging under mischief, so you're arguing breach of trust for a piece of property.
We're talking, it's kin, I guess we argued a kin to say that
I understand, but I'm guessing that's what the other side's going to attack. I mean, I would if I were them.
They could say that.
I like the argument.
Yeah. But even if it wasn't breach of trust,
you've got the other stuff, but the breach of trust is tricky just because of the charge that's been laid. I understand breach of trust for the harm, for distress, and I like going on mischief. It's one of the first times I've seen it done. I thought it should be done more often because the sentence range is higher for mischief than it is for cruelty. So it strikes me that it's a good thing to do when you can't prove the suffering, but I just wonder how you get to the breach of trust principle in sentence when you're arguing that the property's trust has been breached. That's tricky.
We actually utilize that as an animal, right? And cases on that. And so therefore, the mischief charge, we actually did not charge on the mischief there. The mischief charge was in fact to destroying the house.
I'm sorry, so what did you get him on? It just said mischief.
Killing an animal. I kept a lawful purpose.
Right.
But there were other charges where the mischief in that actually got. We actually thought about charging, that's a good question, the mischief charge on the managed case, the police service dog.
Well, that's what I would have thought. The mischief case is always down.
But the problem is, it actually, the reason why we didn't is because it also arguably is disrespectful and kind of lowers, that it's an animal, that's a living creature. That's the reason why we didn't charge the mischief.
Right.
And it wouldn't probably change the sentence. And we have to still say, and I'm always very careful because I have to be fair to the accused, it's akin to a position of trust. I think the Conrad case, which is before the court right now, and we're waiting for a sentence on that case there where basically it's revenge. So the accused, and these are facts, I can say this, there are facts out there where the accused used to live in the house, he's kicked out of the house, he's fighting with the other 18-year-old, so he lures the dog out, the dog falls, and then bludgeons it to death with a rock. That case, I think, is really a good example of leading a lamb to slaughter, because he's used to playing with that person who used to live there, right? And now, it definitely was a position of trust. There's no way that animal would have fallen back for that he lived in there, right, in the residence here too. But the sentences, there was no, I guess, I'd ask you guys if you guys did research, there was no magic numbers. Like one of the highest sentences we saw actually for solely killing an animal or hurting an animal, the highest really we saw was 12 months in jail. That was unreported. Anything reported really was hard to use because they globalized the sentence. They didn't break it down as to what the break and enter was worth versus, killing the animal. So the highest sentences, and this has nothing to do with the animal clear. This is not like, I hate people go just worse. I'm just saying, I think this is more just people getting more enlightened and maybe me being pushed by people like yourself to look at the law and that and get, some deterrence factors there, right? Is it proper that everyone should go to jail for hurting an animal, causing no injuries? Whereas if you hurt your spouse with no major injuries, you're not going to go to jail probably. I'm not sure. I think that's fair to say here. But so far, I'm left with a situation here that it seems like the courts have said, a variety of them, is that we're looking at jail time when it comes to any type of animal abuse, right? That's what, all those cases, you'll see that all the sentences are clearly that. Even with glowing reports on the Chalmers file, 2 cats several times were thrown against the wall. One has a broken skull, one has a broken leg. That guy had an amazing, I got the decision here, an amazing pre-sentence report on that one here too. But the court said you needed deterrence and denunciation. And sometimes there are some cases where a conditional sentence order, because you need to set apart the individual from society so much, requires it. And so while I appreciate it's limiting the rights to life and liberty of the accused, and I understand where defense counsel is coming, I have to balance off like it's a deterrence factor here. It's like, again, I'm not saying they're people, but in a homicide, any form of homicide, whether it be second degree murder or manslaughter or first degree murder, people are going to be expecting jail time. They want that kind of a behavior to be set apart and saying that this is not appropriate. We're not condoning it. We're not going to accept it. And that's I'm actually quite amazed. How the courts have in Edmonton looked at that and said no, conditional sentence order is not appropriate. Even those ones, and I'm not trying to belittle them, where we got 90 days or 6 months, where they threw the dog out the window and to get a broken back but survived. Still, the judge said jail time. It could be intermittent in the case of 90 days, but it was not going to give a conditional sentence order. It sent a pretty firm message, and it goes back to those 3 cases, Connors, Monroe, and Rogers, where they keep on talking about Parliament's intent in 2008, changing the legislation. In Connors, I think on page 11, paragraph 51, I'm just going to read one of the quotes. To fulfill Parliament's intention in making these more serious offences requires, in this case, that a longer period of incarceration be imposed than the majority of cases decided prior to the amendments. However, this case is also to be distinguished from R versus Monroe, where the events occurred after the amendments and the offender received a 1-year sentence. In that case, the offender perpetuated extended multiple acts of varying forms of torture to animals over many months. And the point here is that it keeps on going into the idea that Parliament's intention. That wasn't the best quote. I think the better one was Rogers, which says, in increasing the penalties, Parliament did conclude that previous maximums were wholly inadequate and failed to represent the prevailing view in society as to the seriousness of these offences. And I've actually used these cases, and I looked at them to Aaron before you guys, in case you're interested, in the courts, because it shows that while at the same time as a Crown, we cannot say that an animal is a person. Nevertheless, we're saying because it's a living creature, it's certainly not equivalent to a water bottle or a shirt or something like that. Because it is a living creature, and we're supposed to be respecting living creatures. Arguably, we're the superior beast too, as well. That when it comes down to animals, the courts are going to take it serious and are going to look at a greater deterrence factor, right? I know some people have to leave because of class and that too. I've left my name and phone number because I don't have any cards right now, but Aaron can also forward that too as well. So I think as we come down to the final few seconds here, the way the animal cruelty laws are going, it's going to be shaped by individuals like yourself. We need to encourage the court systems and the prosecutors and defense counsels to respect it, and we're going to have to look at all the angles too, because as you tell, like we talked about, looking at some of the sections and how to prove them. That it's not, the reason why we had the comments from the animal protection officers, are you going to drop this? People just don't know. Yes, we don't know. We're trying to educate ourselves. We're trying to learn. And when we go to court, it's constantly a learning experience. I'm hoping that we won't keep on hearing from defense counsel, my colleagues, even myself in the courts, it's just an animal. Because how many times do you think I've heard that? Whether it be pretrial conferences, in the courtroom or outside the courtroom. We need to take this really seriously here. As I said, it makes 1/3 of my practice, as Aaron said. It takes approximately 75 to 80% of my time. I volunteered for this. Never had a pet. That's one thing I'm harshly criticized for. Never ever had a pet, but I'm 24/7, so I volunteered to create this portfolio. And it doesn't mean I'm not trying to suggest that, because I really want to do something, make a difference. So people can call me. The Humane Society officers, the bylaw officers, and the police can get hold of me 24/7, and they've allowed it through the Crown's office for me to give advice, so that we can hopefully deal with some of the things in a timely manner, but also lay the right charges. Because we are uneducated and are not familiar with it, a lot of people don't have the right resources, like necropsies or doctors, and that's why I can provide that to the EPS right away, because otherwise the evidence could be lost. So those are my general comments. I know the time went flow quickly.